Good morning.
Morning.
We are on the record in dockets 22022459 and 22022481. We'll start with 459. In the state of Michigan versus Marshawn Curtis. Will the parties please introduce themselves to the record? This is the time set for preliminary examination.
Good morning, Your Honor. Melissa Patrick on behalf of Mr. Curtis, who's here to my right.
And sir, you are Marshawn Curtis?
Yes, Your Honor.
All right. This is the time set on this file for preliminary examination. How are we proceeding today?
We're stipulating to an adjournment, Your Honor. Council just got the discovery. I was under the impression yesterday that she had it already, so I think it's a reasonable request and I'm willing to agree to an adjournment.
Right. So there's a stip to adjournment on today's preliminary examination. Is that your understanding, Ms. Patrick?
That is my understanding, but I want to make a correction. I still don't have the discovery.
Oh.
I'm still waiting on it. I did submit the signed substitutions to the prosecuting attorney's office yesterday. I'm just waiting on discovery.
All right. And would your client be willing to waive his right to a prelim within 21 days in order to comply with the discovery request?
I need to have a brief chit chat with him about that, Your Honor.
All right.
Okay.
So if you want to take some time to talk to your attorney, Mr. Curtis, if you want to take some time to speak with your lawyer, I can go in my chambers and allow you some time to speak to him about that waiver. Okay. All right.
All rise. All the stuff that he did take
Okay.
Oh, yeah. Yeah. I mean, there's no restitution because they got.
Right.
Yeah. Or I mean. Oh, perfect. As long as it gets sent to my office. Thanks, man.
As soon as I sign it, I always.
record docket 22-02459. If this is gonna be also on the record docket 22-02481. Ms. Patrick, did you have the opportunity to consult with your client concerning the 21-day waiver?
Yes, I did, Your Honor.
All right, and may I make inquiry of your client concerning
Yes,
that
Your
waiver? All right. Mr. Curtis, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment. And a preliminary examination is what we're scheduled here for, and that would be a probable cause hearing in which the people would have to prove by probable cause evidence that a crime was committed in this file, 22-02459. And we can go ahead and do both files. I'm assuming 22-02481, that a crime was committed in both files and the identity of the person who committed those crimes. Do you understand that, sir? And you'd have your attorney, Ms. Patrick, here to contest any charges and cross-examine any witnesses that would be brought by the people against you. You have that right within 21 days. If you waive your right to have the prelim within 21 days, you wouldn't be waiving your right to a preliminary examination only within that time period, within the 21-day time period. And my understanding is that's for discovery purposes, so that your attorney will have all the information necessary in order to present a defense, okay? It's my understanding you wish to waive your right to a prelim within 21 days of date of arraignment. Is that correct, sir? Okay. So I find the waiver of the 21-day rule to be knowing, voluntarily, and accurately made in regards to file 22-02459. Just for the record, in regards to 22-02481, is it your client's intent to also waive the 21-day rule in that regard?
Yes, Your Honor.
All right. So similarly, do you wish to waive your right to a prelim within 21 days concerning the second file, 22-02481? Okay. With a yes to that, I know that you waiver the 21-day to be knowing, voluntarily, and accurately made. We will get a new, and this stipulation to adjournments based on discovery issues and compliance with discovery. Is that correct?
Yes.
Yes, Your Honor.
All right. We'll get a new date for prelim. And since the 21-day rule has been waived, do you have, we'll give you a prelim date and then you can check your schedule to see if it coincides with your schedule.
October 27th at 1:30.
October 27th at 1:30.
That date I do have a problem with.
Okay.
Do you have anything sooner than that?
Uh,
I know we had exchanged emails with your staff yesterday, and they said it's a possibility at Monday or Tuesday.
Tuesday afternoon may work, but we scheduled some hearings for the immediate Tuesday afternoon. We wanted to block off time for this so we wouldn't have any interruptions, but then that time, so let's.
Next available day, unless we do it next week. We could do the 14th at 1:30. It's a Friday, October 14th.
So would Friday, October 14th at 1:30 work?
I have a mediation scheduled on a divorce case that morning. I'm not sure if we'll be completed by 1:30.
All
Do we
right,
have an anticipation of how long the exam may take?
2 files. If we ran both exams, how, a couple hours?
Yes.
Yeah, I would think. So how do we look on Friday, the 21st?
The 21st of October?
Yeah, or is that the date that it presents a scheduling conflict?
I have availability from the detective and the witnesses issues with those 2 dates. I have the 13th, the 17th, the 18th, the 20th, 24th, the 25th open. Sorry.
Yeah, you're gonna have to speak up, so.
Oh, I'm sorry.
I'm just so we make sure that we get a scheduling date that works.
Right, that's why I'm texting with the detective, and so that date, the 14th is not on the, we don't have, we're not available, but I have the 13th, the 17th, the 18th, the 20th,
Not
the
the 13th,
24th, and the 25th.
the 13th at 2.
That's great.
I'm in Judge Garcia's at 2 o'clock on the 13th.
All right. The 20th, does the 20th work?
Yes, that'd be great.
The 20th in the afternoon?
I'm
Yes.
afraid that you're in a conference that day.
So let's, does 2 o'clock work with you?
Yes.
So let's go 2 to 5. We'll block that time off.
You're scheduled for that.
Yeah, but I don't have to be there in the afternoon, yeah. So let's do October 13th.
Oh, the 13th.
You said
Oh, I'm
20th.
sorry, October, that was on me.
Okay.
October 20th
At 2.
at 2. October 20th at 2 p.m. for the new date for the prelim. All right, so we have a new date on both files. Anything else from the Assistant Attorney General?
No, Your Honor, thank you. so
Anything
much.
else from the defense, Ms. Patrick?
No, Your Honor, thank you.
All right, so that's all for the record and doc on both cases, 22-02459 and 22-02481. We'll see everybody back here on October 20th at 2 in the afternoon.
Thank you.
You're welcome. All right, Mr. Abbott, I'll put yourself and Mr. Burleson in room 1. I don't know if I did open all breakup. How do I do that? Hold on. There. There we go. All right. And this is so we're on the record in docket 220207. That's People of the State of Michigan versus Patrick Lamar Greer. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Patrick Greer, who's standing to my right, Your Honor.
And sir, you are Patrick Lamar Greer?
Yes, sir.
All right, this is the time set for preliminary examination or probable cause conference today. Ms. Lacy, how are we proceeding?
Your Honor, it's my understanding that at this time, Mr. Greer is gonna take advantage of the plea offer that was extended to him.
All right, and what is that offer?
1 second, Your Honor, make sure it's listed in
Okay.
appropriately. On this trial, Your Honor, the offer is for Mr. Greer to plead to an added count 2 of use of methamphetamine that is contrary to MCL 333 74, I believe it's. let me make sure it's correct. 7404, paren 2, paren A, that is a misdemeanor punishable by up to 1 year and or a $2,000 fine. In exchange for that plea, Your Honor, the people would agree to dismiss the original count 1.
Mr. Feigelson, I'll restate the plea agreement as I understand it, and then you can correct me concerning the offer. There's an offer to plead to added count 2 of use of methamphetamine.
Your Honor, that's accurate, but what I was under the impression from speaking to Mr. Wisty is this was gonna be part of a global plea up in the circuit court because he has a case pending in front of Judge Aquilina. The offer will remain a use, but I think we would be pleading up in circuit court on said offer.
Oh, so the offer would be on the table and
Yeah.
then they'd be waiving waiving from district court to circuit court.
Correct, Your Honor.
Okay.
Sorry, Your Honor, that's more than likely correct. I don't have clear notes in my file.
All right.
So,
So this would be a waiver to circuit court. And so let me understand, I'll place the plea offer on the waiver. It's my understanding you're going to waive to circuit court. Well, this will be resolved with another case. All right.
Yes, that's correct,
That's
Your
my
Honor.
understanding. Okay, so the outstanding offers to plead to an added count 2 of use of methamphetamine pursuant to 333.7404, parents 2, parents A. That's a 1 year under $2,000. Dismiss count 1. This offer will go to circuit court where it'll be resolved with another case.
Correct, Your Honor.
and then, Your Honor, because of my misunderstanding, I don't think I placed it on record, but the people would also agree to unconditionally waive the rights to. pay
All
the
right,
retainer
thank
in
you.
this matter, yes.
All right, so Mr. Feigelson, that's your understanding. May I inquire of your client of his waiver of preliminary examination?
May, Your Honor.
All right, so Mr. Greer, you understand that you have a right to a preliminary examination today. That is a probable cause hearing in which the people would have to
Yes, sir.
prove. Okay, you're good. You can sit down if you need. to.
Okay.
So that would be a probable cause hearing in which the people would have to prove by probable cause evidence that a crime has been committed and the identity of the person committed that crime in this file, 220207. You, of course, are represented by Public Defender Steve Feigelson. He would contest any charges or cross-examine any witnesses brought by the people in regards to your defense. If you waive your right to a preliminary examination in this matter, then you'll be leaving district court, you'll be going to circuit court. Well, this case will be taken care of with other cases. You heard the plea offer that's out there. This is a global resolution, so there's another felony out there that will be resolved, so negotiations will continue. Do you understand that today, sir? Is it your intent today and wish to waive your right to a preliminary examination in district court?
Yes, sir.
All right. With that understanding, I find the plea agreement, I find the factual basis for the waiver to be freely, understandingly, and voluntarily given. We've discussed the plea agreement. The prosecutor also waives their right to a preliminary examination. And so this case will be bound over on a waiver to circuit court. And so keep in contact with your attorney, Mr. Feigelson. You'll get any circuit court date from Mr. Feigelson where you need to appear, all right?
Sir.
Anything else for the record in docket 22-02077, Ms. Lacy?
No, Your Honor.
Anything, Mr. Feigelson?
No, Your Honor.
All right, that's all for the record in this file. Good luck to you, okay?
I'll be in touch shortly. Today's the 6th.
Yes, October 6th.
It's 430 North Lodge Street.
All right, we're on the record in docket 22-01867. That is the people of the state of Michigan versus Martin David Hodges. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Hodges.
Sir, you're Martin David Hodges? All right, thank you. This is the time set for a probable cause conference. Ms. Lacy, how are we proceeding?
Your Honor, at this time, it is my understanding that both the people and the defense agree to unconditionally waive the right to preliminary examination. And instead of having it bound over to the circuit court, Mr. Hodges is going to be entering a misdemeanor plea.
It'll be a misdemeanor plea in district court. And what is the nature of the plea?
Mr. Hodges is going to be pleading guilty to an added count 2 of larceny, 200 to 1,000, contrary to MCL 750-356(4)(a). That is a misdemeanor punishable by up to 1 year and/or $2,000. In exchange for that plea, the people would agree to dismiss count 1. And then just for the record, Your Honor, all merchandise that was removed from the building was recovered, so there is not going to be restitution.
All right, so I'll restate that for the record.
There's, Judge, you may need a minute.
All right,
Sorry.
so we'll allow counsel to talk for a minute and then we'll go back on the record.
Thank you. Yeah, I have that.
Yes. Thank you.
Your Honor, I'm gonna amend that offer on the record.
All right.
We're ready.
So we'll go back on the record, docket 22-01867. I'm assuming this is a sentence agreement.
No, Your Honor, and it isn't. There was some confusion, I think, between the communication between Mr. Whiskey and Mr. Feigelson.
Okay,
But based on the defendant's history, I'm willing to amend the offer for Mr. Hodges to plead to an added count two of larceny under $200. That is contrary to MCL 7503565.
5.
That is a misdemeanor still. It is, however, punishable by up to 93 days and or a $500 fine.
All right, so I'll restate the negotiations as I understand them. There's an added count 2 of larceny under $200 pursuant to 750.356 parents 5 parents A. That's a misdemeanor 93 days and or $500 with a plea to that count 2. Count 1 is to be dismissed. There is no restitution in the file.
Your Honor, just to make sure that we're clear on the statutes, I don't want to mess it up. I don't want it to confuse the
Sure.
court staff. It's 750-356 parent 5.
Parent 5.
Yes.
And not a parent A.
No A after that.
All right. Parents 5. Is that your understanding, Mr. Ferguson?
It is, Your Honor.
All right. And your client wishes to plead to the misdemeanor count today?
Yes, Your Honor.
All right, and you've provided the court with an advice of rights that I'll put in the file. May I inquire of your client concerning his misdemeanor plea?
You may, Your Honor.
All right. So, Mr. Hodges, you understand that you've gone over some of these rights with the plea, but I'll just go over them with you. The maximum penalty concerning this misdemeanor is a 93 days, up to 93 days in jail and or $500. Do you understand that, sir?
Yes, sir.
All right. If your plea is accepted, you will not have any trial in this kind. If your plea is accepted, you will not have a trial of any type of this kind. So you'll be giving up these following trial rights if you plead guilty. You'll be giving up the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond a reasonable doubt that you are guilty, to have the witnesses against you appear at trial, to question those witnesses at trial. You, of course, are represented by Public Defender Steve Feigelson. He would be present to contest any charges and cross-examine any witnesses. Do you understand that, sir?
Yes, sir.
In trial, you have the right to have the court order any witnesses appear on your behalf for your defense. You'd have the right to remain silent during trial and not to have that silence used against you. You also have the right to testify at trial if you choose to testify. All in all, if you plead guilty, you will give up the claim that the plea was a result of any promises other than threats that were not a choice, that it was not your choice to plead guilty. Do you wish to plead guilty today, sir?
Yes, sir.
All right. You'd be also giving up any appeal rights that would go to a trial, the circumstances that would happen in a trial, because you're not going to have a trial, you're going to plead guilty. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. I'm going to bring your attention back in regards to count 2, which is the larceny under $200. On July 16th of 2022, at the offense location of 518 Seymour Avenue, City of Lansing, Ingham County, State of Michigan. Were you present at that time on that date in the City of Lansing, Ingham County?
Yes, sir.
All right. And my understanding is pursuant to, why don't you tell me the factual basis for what makes you guilty of count 2 today?
Oh, I was under the influence of meth. I went and saw the window open and couldn't resist. I went into the building.
All right. And when did you go into the building for?
First, just curiosity, but then I saw some stuff. I liked it. Thought maybe I'm homeless.
Okay,
I thought I could hustle it, maybe make some money.
all right. So, and that was not your property, it was somebody else's property. Okay. And that was under the amount of $200. All right. I find a knowing, any questions concerning the factual basis, Ms. Lacy?
Just so that the record's clear, Your Honor, was your intent, Mr. Hodges, to steal those items? Is that correct? At some
It probably
point,
was to make some money off it, so yeah, it would be yes.
and you weren't going to return those items,
No.
correct? Okay.
And I think the intent could be formed as long as he took some items that weren't his. I don't think it matters that it was in a building or not, but I appreciate that.
Correct, yes.
Okay.
It's, that's no further question. Your
All
Honor.
right, Mr.
You guys-
Feigelson.
I don't have any for the factual.
All
I
right.
think it's accurate.
I find the factual basis to be knowing, voluntarily, and accurately made. As to count 2, which is the larceny, under $200. Ms. Lacy, do you or Mr. Wissy, were you left any notes in regards to sentencing on this matter?
No, Your Honor, I don't have any notes from Mr. Wisty with regards to sentencing on this matter. It's my understanding from speaking to Mr. Feigelson that Mr. Hodges has done quite a bit of jail time with regards to this case and the case that's in Clinton County. So I would leave the sentencing to the court's discretion. I don't have any objection to immediate sentencing.
All right, that was my question. Mr. Feigelson?
Your Honor, I would ask for immediate sentence today. A couple of things I would point out. One, that the property that was taken from the company got it back. He's sitting on a misdemeanor almost sentencing at the end of this month in front of Judge Carrizio, so I'd ask for sentencing today.
Do you know how much time he has in on this offense?
I think he's been in since September 2nd, is that right?
Yes, sir.
September
The
2nd.
warrants are what they write them down.
All right, so if there's no objection, I'm gonna go to immediate sentencing on this.
No objection.
The court will order sentencing as time served on this offense. I do have to order, I'm gonna waive fines and costs in this, but I do have to order some mandatory state fees.
Right.
So crime victims' rights fee of $75 and a state fee of $50 for $125 fee. There, my understanding, there's no restitution in this file. Sir, I understand that you'll be incarcerated on this. So once you're able to get out, I'm gonna put any type of, contact the city so they don't show cause you on the fines and costs of this. It's $125 and I'm gonna put it out 60 days. All right. So it'll be 60 days. You'll have to at least contact them and set something up in that regard. All right.
Judge, I do want to point out, he will be back in front of you on a City of Lansing case on the 18th of this month.
All right.
Run that.
But we can't, I have no power to do anything because it's two separate.
Right,
Prosecution.
to something on the ordinance, but we'll make a note of that. Wendy will make a note of that. And we'll just keep it at 60 days just to put it out there. So you have plenty of time to contact. And then any more fees will have the same date, but we'll just keep that 60-day date out there. Just to alleviate any show cause or any type of anything that happens in that regard.
False information.
Yes.
What's- So 60 days would be. Fancy calendar. December 6th, 60 days. So contact the city of Lansing. The city of 60 days to pay fines and costs. Contact the city of Lansing by December 6th. If, depending on your availability, but I just want to make sure that somehow you get in touch with them so they know where you are. Okay. All right. Anything else for the record in docket 2201-867, Miss Lacy?
Nothing from the record, Your Honor.
Anything, Mr. Five?
No, Your Honor, thank you.
Mr. Hodges, do you have any questions?
Judge, I think he's not gonna be out by the,
By the 6th?
yeah.
All right. Let's if that's true, we'll let the city know that you're incarcerated. We'll extend the date. Okay, all right, yeah, just to avoid any problems in that regard.
Well, the reason I'm bringing this up is because I'm hoping this is gonna send me to a program. And I don't want, and they're probably gonna give me 6 months and then a program.
All
And
right,
so I don't want anything like to come out as a warrant and then stop me from being able to go to this.
right,
program.
that's in Clinton
That's
County,
why-
right?
Yeah,
All right. Let me put on here 60 days from released from incarceration. Because I'm assuming that the program, you'll technically still be under the court's jurisdiction
Right.
going through the program.
and probation. and
Yeah.
all that.
We'll make sure and make those notes, and then we'll look at this again when we get the ordinance case in a few weeks, okay? All right. Anything else for the record, Mr. Fagel?
No, Your Honor. Thank you.
22-01867. Good luck to you, Mr. Hodges. We'll see you in a couple weeks.
I appreciate that.
So we're on the record in docket 22-02557. People of the state of Michigan versus Toby Burleson. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. John Abbott representing Mr. Burleson. He's appearing by video from the jail.
And sir, you are Toby Burleson?
Good morning, Your Honor. I'm Toby Burleson.
All right, and you can hear me all right, Mr. Burleson?
I can.
All right, thank you. Miss Lacy, this is the time set for a probable cause conference. How are we proceeding today?
I'm gonna defer to Mr. Abbott at this time. It looks like there was an offer extended for the defendant to participate in the mental health court at the 55th District Court. So I'm gonna let him tell us what we're gonna do today.
That's correct, Your Honor. Mr. Burleson has a case currently pending in 55th, and I've received an email that they want to get him involved in that specialty court there, whether it's the mental health or the alcohol abuse. And I spoke with Mr. Burleson about that. He does admit that he could use some help dealing with alcohol. So I asked the court to let us waive the 21-day rule, Your Honor, to continue that negotiation and hopefully come up with a solution without preliminary exam in the future.
All right, so my understanding is that your client's willing to waive his right to a preliminary examination, and there's continued discussions concerning having him participate in the 55th District Court, alcohol court, or mental health court.
I think it's going to be alcohol.
Okay,
And we're not waiving the whole preliminary.
right,
exam.
just within 21
It's
days.
the 21-day.
Okay.
Yes, Your
And that's your understanding, Ms. Lacy?
Yes, Your Honor.
All right. May I inquire of your client of his 21-day rule right?
Yes, Your Honor.
All right. Mr. Burleson, you understand that you have the right to a preliminary examination within 21 days of your date of arraignment today. Do you understand that?
Yes, sir.
All right. And a preliminary examination is a probable cause hearing in which the people of the state of Michigan would have to prove by probable cause evidence that a crime in this file was committed and that the identity of the person who committed the crime in this file. You, of course, are represented by Public Defender John Abbott, and he would be available to cross-examine any witnesses and contest any charges brought against you by the state of Michigan in that probable cause hearing. Do you understand that, sir?
Yes, sir.
It's my understanding that if you waive your right to a preliminary examination, you'd only be waiving your right to a preliminary examination within that 21-day period. You would not be waiving your right to a preliminary examination in its entirety. So it's only waiving that right within 21 days. Do you understand that, sir?
Yes, Your Honor.
Is it your intent to waive your right to a preliminary examination within 21 days today?
Yes, Your Honor.
And I'm, Miss Lacy, the people also waive their right to a preliminary examination within 21 days.
Yes, Your
It's, I
Honor.
know it's the defendant's right, but we'll just put that on the record.
Yeah.
And I'm going to indicate this is for purposes of seeking additional 55th district alcohol treatment or specialty court. I'll just put specialty court treatment.
It never went off until that moment, and I'm in here. This is my grandmother's funeral, and my son's birthday is coming up on the 17th, but I don't have court until the 19th. I don't even know why I'm in here, except because the judge said contempt. And I'm wondering, will I have a chance to see that?
We should get a new prelim date.
How about November 3rd at 8:30? That'll give them about a month to try to get. through the
Is that
screening.
about work?
That should be fine, thank you.
All right, so I'm gonna set a new prelim date just so that we could have some screening for November 3rd
3rd at 8:30, please.
at 8:30. All right, Mr. Burleson, you understand that this has been set for November 3rd at 8:30, your preliminary examination date. Of course, during that time period, there'll be some continued negotiations in order to seek specialty court treatment in 55th District Court. Do you understand that, sir?
Yes, Your Honor. I
All right.
understand.
Any questions concerning the waiver of the 21-day rule or the new date on file 22-02557, Ms. Lacy?
No, Your Honor.
Anything, Mr. Abbott?
Now, in regards to the 21-day waiver, Your Honor.
All right.
In regards to bond, Your Honor, has there been a bond report created yet?
There's not been a bond report. I have bond indicated at 4,010%, and there's not been a bond report created.
I request that the court order a bond report so I can raise that issue at our next opportunity.
All right.
Thank you.
So okay, so for the record, I've indicated that there's a request and it's been ordered that a bond report be done in this file in regards to a review for next year.
Thank you, Your Honor.
All right. Anything else for the record, Mr. Abbott?
No, thank you.
All right, Mr. Burleson, we'll see you on November 3rd at 8:30, all right?
I'll see you on November 3rd. Thank you.
All right. That's all for the record in this file. That you have Miss Walton with us too.
That's the one for the car. That's the one for the car. But the one for 2018, Michigan State Police, I was literally a patron at the Kellogg Center. And I spent $400 that day. I bought an outfit that cost over $200. It was a Michigan State Nike jersey and the matching pants and everything. I ate at the Kellogg Center. Paid for my food and everything. They can check the cameras. Next thing you know, while I was waiting on a ride, they came and arrested me. I did nothing wrong. I didn't even bother anybody. I didn't talk to
So we're on the record in docket 21-00502. That's people of the state of Michigan versus Michael Sean McPhee. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. Jacob Sarge IV, Assistant Public Defender here on behalf of Mr. McPhee. Mr. McPhee is present at council table. He's standing to my right.
And you are Michael McPhee, sir?
Yes, Your Honor.
All right. This is the time set for a, what are we here for? A preliminary examination is set, and then we have a second file that we discussed a little off the record on a PA 53 violation. Ms. Lacey, how are we proceeding today?
With regards to the file that's up for the preliminary examination today, Your Honor, it's my understanding that at this time, Mr. McPhee is going to unconditionally waive his right to preliminary examination, and the people would also agree to unconditionally waive their rights to preliminary examination. With regards to the PA 53 violation, I would defer to Mr. Sartz.
All right. And is that an unconditional waiver? Are negotiations to continue?
It looks like based on the notes, that an offer potentially was already extended to Mr. McPhee,
All
but
right.
I would have to confirm that with Mr. Sartz. I'm not
All
sure.
right. Mr. Sartz, my understanding, and then you can correct me, that this is an unconditional waiver from district court to circuit court, and that you and Mr. Wisty have spoken and negotiations are continuing.
That's correct, Your Honor. Mr. McPhee's offer initially is a 1-for-1. He could choose to pick to plead guilty to one felony. In exchange, they would dismiss the other one. That's the initial district court offer. Mr. McPhee also has matters pending out in Livingston County. What I expect is up at circuit court, we'll try to work out some type of global resolution that can accommodate both counties if that ultimately is the path that Mr. McPhee would prefer. Of course, it's always his choice in these situations. Thank you.
Thank you. May I inquire of Mr. McPhee of his waiver?
Yes.
All right. So you've heard the lawyers talk today. I'll talk a little bit about the purpose we're here for, and then the waiver to circuit court. You understand that there is an offer on the table, negotiate, but there are other matters that may be pending that would be negotiated in circuit court. All this would be done in circuit court, not in district court. Do you understand that, sir?
I understand, Your Honor.
All right. This is the time set for preliminary examination. And preliminary examination, the people would have to prove by a probable cause evidence standard that a crime was committed and the identity of the person who committed that crime in this file. You, of course, are represented by Mr. Sartz from the Public Defender's Office, and he would contest any charges and cross-examine any witnesses brought by the state in regards to the probable cause hearing. The people also have a right to a preliminary examination today. It's my understanding it is your wish to waive your right to a preliminary examination and have this case move on to circuit court, where the discussion has been already indicated, negotiations are continue, and there is an offer on the table. Is that my understanding, sir?
Yes, Your Honor.
All right. Is it your intent today, and do you wish to waive your right to a preliminary examination?
That is correct.
All right. And the people also waive their right to a prelim?
Yes, Your Honor, we do.
All right, I find the waiver to be freely, understandingly, and voluntarily made. We've discussed the plea agreement. The prosecutor also waives their right to a preliminary examination. And so I accept the waiver and bind this court over, accept the waiver and bind this file over to circuit court. Mr. McPhee, please keep in contact with your attorney, Mr. Sartz. He will provide you with any further dates in circuit court, all right?
Yes.
But your time in district court now is done, all right, sir?
All right.
All right. Anything else for the record, Ms. Lacey, in docket 21-00502?
No, Your Honor.
Anything in regards to the prelim file, Mr. Sartz?
Not in terms of the prelim, Your Honor.
All right. So I'm gonna go ahead and sign the prelim document that you previously signed. And then for the record, there's also a PA 53 violation that I didn't seem to understand what the violation was, but now it makes sense to me that the violation was based on a fail to appear from a previous preliminary examination on this case.
That's correct, Your Honor. Going back, and my apologies, I don't have the file right in front of me, but it was, I think, July of 2021 or.
I think it was June 3rd of 2021 was the FTA. So on this date, in order just to clear things up, we're going to dismiss the PA 53 violation. Do you have any comment on the PA 53 violation, Ms. Lacey?
No, Your Honor.
All right. So it looks like a fail to appear violation, and I'm gonna dismiss the PA 53 violation. Since you're, Mr. McPhee is obviously in custody and we know where he is now, so there's no need to have a PA 53. So dismiss that PA 53 violation based on FTA. Anything else for the record in regards to the PA 53 violation, Ms. Lacy?
No, Your Honor.
Mr. Sars?
Nothing further. Your Honor.
All right, that's all for the record in docket 21-00502. Good luck in circuit court.
All right, thank you.
You're welcome. That's People of the State of Michigan versus Oscar Valencia. Will the parties please introduce themselves for the record?
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
And Assistant Public Defender Scott Nickel on behalf of Mr. Valencia, who is present standing to
And-
my.
Sir, you are Oscar Valencia?
Yes, sir.
All right. This is the time set for a, looks like a preliminary examination schedule. Ms. Lacy, how are we proceeding today?
Your Honor, with regards to Mr. Valencia, I only show a bond violation scheduled, so I apologize if I'm incorrect, but it's my understanding.
I think that's right. I think it's right in the middle of a bunch of prelims, so, yeah.
At this time, it's my understanding that Mr. Nickel is going to be asking for an adjournment of that bond violation. The people have no objection to that adjournment, so I'll defer to him.
All right, and Mr. Nickel, here's my understanding of the case, and then you can confirm it. This is an adjournment of the bond violation and to be set for plea in front of Judge Buchanan. Along with the bond violation in order for Mr. Valencia to take advantage of the specialty court that Judge Buchanan runs. Is that my understanding?
That is correct. Mr. Valencia met with Ms. Strauss earlier this week. He's been screened. He's eligible for the program. Judge Buchanan is willing to allow Mr. Valencia to participate a second time, and he wishes to do that. And so my understanding is to get that done, the case has to be set for a plea in front of Judge Buchanan. We'd ask that the bond violation be set at the same time. so that Judge Buchanan and the sobriety court team can address Mr. Valencia's situation as a whole at the time of that plea date.
And I have it on September 3rd at 23rd. It came to me. This is just my notes. Did Mr. Valencia waive his right to a prelim within 21 days on that date?
He did,
Okay.
and we did that so that he could be screened for sobriety court.
So I'll indicate defendant already waived his rights to a prelim. I believe that to the case. I believe that was the case. I just couldn't tell from my notes. What's that? Let Ms. Buchanan handle that. Judge Buchanan. Wait, you can't enter sobriety court without a plea either. So my understanding, so everything's done, we're moving the warrant, there's a pending warrant.
Would either the court or Magistrate Milmore be able to, it's a warrant for non-payment of a fine.
It's a collections warrant?
It's a collections warrant from several years ago.
Right.
Mr. Valencia is prepared to make an initial payment today and set up a payment plan with collection.
You can find the file, I'll do it as a part of this, yeah. All right, so let's get the adjournment, we'll stay here for a little bit and get somebody to grab that file, all right?
Thank you, Your
So Mr. Valencia, you understand today's file is adjourned for a plea in front of Judge Buchanan. And the reason for is that specialty court status. And then we're going to keep you here just for a few minutes until we get the collections file. Anything else for the record, docket 22-00684, Ms. Lacy?
Nothing for the people, Your Honor.
Anything, Mr. Nickel?
No, Your Honor, is the court going to set that today or are we going to get that in the?
As soon as
My understanding is, I'm emailing you now right now.
right.
Kelly said that she would email everything when she got back on Tuesday, just switch everything around and just to get her the file. But my understanding is she said that they were willing to be at the same time you schedule for an exam with us. Next week.
So set the things for the October 14th date next week,
Yeah,
but in front of Judge Buchanan.
That was my understanding. from-
all right.
That would work perfectly.
All right, so let's schedule everything for October 14th, 2022. That's my prelim and then their plea, right?
Yes,
Okay,
it will just be there, please,
and then they're gonna do the arraignment also.
that we were doing.
All right, we'll do the arraignment. Yeah,
It's up to you.
yeah. I'll do the arraignment just to get it out of the way,
Okay.
right? I'll just need that file.
14th, it's October 14th.
Yeah, October 14th.
Do you know what the time was?
Just a second. It does. Need the time, just a date. Thank you. She'll figure it out.
At 9 o'clock. All right, and then Nathaniel, if you get me that collections file, we'll go ahead and, oh, that's right. So we'll get the collections file as soon as,
I'll go get it, or if
yeah, as soon as somebody from the staff will go grab it.
Just have a seat, we'll get that. No, stay here, because then he'll arraign you.
That way Judge Buchanan gets everything pretty clean,
Yes.
or as clean as we can get it.
And so there's not a warrant. sitting here.
Right, exactly.